Ms. Richards.
Sir, wanted to ask you next a little about the concepts of explicit and implicit consent. I think in the letters of instruction we'd use the terms express and implied consent. Your report explains that you favour the terms explicit and implicit. I just wanted to ask you a little about the potential problems with implicit or implied consent. Could you just outline for us, first of all, what that concept covers and then what the problems might be? Professor Cave?
Yeah, certainly. So the reason why we thought it was better to talk about implicit consent rather than implied consent is because there's a risk that using the word implied might mean that there was confusion, that we might be talking about the doctor or other clinician imposing a view that was rationally good from their point of view. And we didn't want that to be incorporated within the term of implicit consent. So rather, implicit consent means that when a patient indicates through some way that they agree to treatment, then it might be acceptable to utilise that as the relevant consent for that particular action. So, for example, for minor procedures, such as if a patient were to come to the doctor complaining of a sore throat and they were to open their mouth when the doctor comes towards them to examine them, that might be seen as an implicit consent because it's clear what's about to happen and they agree with what's about to happen and there's no need in that situation to say, will you consent to this particular thing? And certainly no need in that situation for a written consent form. But when we move away from that to situations where it's less clear that they have indicated that that's what they're expecting, then that's much more problematic because whether consent is express or implied, it still needs to be informed. And to be informed, you need to know what it is that you're consenting to. Perhaps if I stop there unless others come in.
I think that's very clear and helpful. I think one of the things one has to think about is that as the GMC recognises very directly in its latest guidance on medical decision making, sometimes explicit consent processes can disrupt a normal flow of events and become onerous and problematic. However, whilst that allows you to see certain voluntary actions as implicit forms of consent, you're also asked to be very acutely aware of what's going on in the situations where you do rely on someone putting their arm out or turning up for a consultation, and that you don't over-interpret people's actions. The fact that someone comes to a long-awaited outpatient's appointment does not tell you very much about what they wish to follow on from that. And one of the other things I think we've got to become very careful about is that if you, for example, take a blood sample from someone these days, you might feel that you have done the work by expressly requesting their consent to stick a needle in their arm. But in a way, that's the relatively unproblematic part of the process. It's the information that you are going to seek to establish on the basis of that blood test that opens up the complex and enduring ethical issues. So again, whilst we might feel that there are certain procedures that become quite routine and expected, and we happily go along to some degree with those just happening, where we understand that actually they're the gateway to quite a complex issue of questions and issues, long-term issues that are very important to a patient, we've got to be very explicit, even though a clinician might have come to think of them as quite routine.
So if you have a patient who rolls up their sleeve and acquiesces in the administration of, might be a blood product or something else entirely, which carries with it a small but not insignificant risk of a fatal complication or fatal side effect which hasn't been explained to the patient, the limits of implicit consent would mean you could possibly say that patient's implicitly consented to the physical act of being injected, but they've not consented to the overall procedure or to running the risks because the procedure's been carried out with the patient left in ignorance of the risks. Is that right?
Yes. Yeah.
But even if there was express consent to the taking of the blood, let's say, but there wasn't an understanding of what that blood was being taken for, that would be problematic because they weren't informed as to why that was happening and what would follow as a result.
Can I ask you next just a little about the therapeutic privilege or therapeutic exception? Could you just outline, first of all, what that is?
Its nature has changed over time. What it is today is an exception to a rule that patients must be informed of material risks. And material risks in law are risks that a reasonable patient, or that particular patient, if it's reasonable to understand that that's what they want to know, need to know in order to make that decision. But previously, it was referred to as a therapeutic privilege, and it was seen as a broader part of the discretion that doctors had when working out what to tell a patient, what information to tell a patient. If they didn't tell that patient certain information, then they might be held liable in negligence. But at that particular time, so from the late 50s until really fairly recently, if they did what a reasonable doctor would do in that situation, then they wouldn't be liable in negligence. So the question would be asked, would it be reasonable in this situation not to tell the patient in this type of situation this particular information because they were likely to be harmed as a result of it? Now, when we apply the exception to the general rule, it's recognised that you can only apply that exception if serious harm would befall the patient. But previously, the level of harm required wasn't as high.
Is it right to understand the therapeutic privilege, now therapeutic exception, as a purely legal rather than ethical concept?
No, I don't think so. I think we also find it in a number of guidelines, recognising that there are times when putting the patient first means not giving them certain information that could cause them harm.
So maybe you'll come to this, but there is in the ethics literature a similar concept of the right not to know. And this often comes up in genetics. The people have a right not to know information that, for example, doesn't have any preventative medical value. Huntington's disease is the classic example of this, that the psychological distress of knowing information they can't change means that people have a right not to know it. Now, I just want to signal I have quite an extreme view of this. I think you may have a right not to know, but it's not an expression of your autonomy. And the reason for that is as we explained before, autonomy requires you knowing relevant facts about yourself and the world in order to understand what choices are available to you in your life. And so autonomy requires information. And in my view, and this is a fringe view, autonomy does not justify a right not to know. Now, I'm sure maybe Bobby will have a different view. But to give an example, say a patient has a gangrenous leg, is extremely anxious and prone to depression. The therapeutic exception might say, well, we're not going to tell the patient we're going to amputate the leg. We're just going to say we're going to perform an operation. And the patient might say, I don't know, I don't want to know what you're going to do. Just do what you need to. In my view, the patient must be told that an operation to amputate their leg is going to occur, because it's only in that way can they actually make an autonomous decision. Now, it may be that we don't have to always exercise our autonomy, but I think information is very important, and the therapeutic privilege undermines autonomy.
Professor Fastides?
I wouldn't take as extreme a view as Julian does on this. He predicted that. I think we do have a right not to know, and I think it will become more and more important as, over-the-counter genetic testing allows people to find out all sorts of things about their possible futures, not with great reliability at the moment, but in 10, 20 years' time, we might have the ability to sort of map out in some detail our medical futures. There are those of us who would choose not to do this. And I don't think that is because we're shirking any responsibility. It might be because we wish to live our life autonomously in a way where it is not necessary to know these things. So as long as one can discharge responsibilities to others effectively, and I think sometimes you need to know things in order to discharge your responsibilities to others, I would be very prepared to allow people to make their own decision, for example, having been given a particular diagnosis, on the extent to which they wish to pursue information about their prognosis, particularly, again, given that it'll be probably quite unreliable and uncertain, given what we know. So I think one can make autonomous choices to acquire all sorts of different information about one's life that might appear incredibly important to other people. You see it with people, for example, who've been adopted. For some, finding their birth parents becomes a life mission, the most important thing in terms of defining their identity and pinning down their history. For others, it's not. And I think human beings are so varied, and there is a richness to them that whilst I could see very good reasons in probably most cases for people to be well informed about their medical situation, I would also allow people to exercise a right not to know, as long as that didn't have very profound implications for others.
Isn't the right...
Just to clarify, I just want to say that I agree they shouldn't be forced to know, but my argument is it's not particularly promoting their autonomy. But also I think it's important to see that on something like this we can have a reasonable disagreement, and there can be differing positions. And I think that's something that's important for your inquiry, that there can be reasonable disagreement about what the right thing to do is. And I'm not saying that Bobby's right and I'm wrong, or vice versa. So I think that's the nature of ethics. Not everything is resolved. There can be arguments for and against very different positions. Sorry, Emma, I just wanted to...
Not at all. I think the law is quite helpful here. And my interpretation of the law is that a patient must be given basic information, such as not just we propose to perform an operation, but this operation will be an amputation of your right leg. So enough information for them to be able to give a valid consent. Otherwise, the doctor may be guilty of an assault. The therapeutic exception doesn't apply in that case, as far as I am aware, at least. Rather, it applies to the duty and negligence to disclose material risks, which is quite a different thing. Furthermore, the law is clear. So the Supreme Court in 2015 in Montgomery made clear that patients are able to say that they don't want that particular information about material risk. So patients are able to say, I don't want to know that. Now, of course, it's a little bit difficult for them to work out what they don't want to know before it's been made clear the type of information that is about to be made available to them. So it's rather complex to negotiate. But in law, at least, the therapeutic exception has rather a narrow meaning.
I understand the right not to know, and the precise philosophical basis for it may be a matter for some dispute. But the therapeutic privilege, at least pre-Montgomery, doesn't involve the patient deciding not to know, does it? It involves the clinician deciding not to tell. How is that ever justified in ethics, other than perhaps in the most extreme of cases where telling the patient the clinician has reason to believe might precipitate an immediate act of fatal self-harm?
I'm perhaps not the best person to talk about the ethical side of things because my focus is more on the law, but I just want to make the point that as this privilege was developing, the law wasn't very clear in relation to mental capacity. So part of a therapeutic privilege was recognising that a patient wasn't able to deal with particular types of information, and that if that information were given to them, they would be rendered unable to decide. So part of the operation of it was working out, well, will the patient be able to cope with this information? And if not, what will be the consequence for that patient? Now we have a much clearer understanding of the rules and laws around mental capacity and a framework that's put in place to act in the best interest of patients if they're not able to deal with that particular type of information. So some of the early cases on the therapeutic privilege now would be dealt with under the Mental Capacity Act, because that patient perhaps had a needle phobia or some other condition which meant that they couldn't deal with that type of information.
So I think that I completely agree with Emma, and I think that in the past it was an example of what I called soft paternalism, that the doctors felt that patients were unable to use the information in a meaningful way, were unable to cope with it. I think that is almost always a mistake. It's exactly like the argument that the patient shouldn't be told they have a terminal diagnosis, which still occurs in some parts of the world, that doctors felt they were unable to cope with that information. And I think that denigrates the patient and fails to respect them as a person. So I think it was based on a mistaken belief about human capacities and also the ability of people to live their own lives.
I would agree with you, and I think also it fed off a tendency to stereotype patients as being a sort of particular group who didn't have access to the same expertise and knowledge, and we now understand that patients can be brought to a very good understanding of their own conditions and can often educate healthcare professionals quite effectively. I think Emma's done us a favour reminding us to think about how the Mental Capacity Act works now, and any newly qualified doctor will now go in with a very clear legal obligation to start with the assumption that their patients have capacity, and only to move away from that if they can see that there is evidence to suggest that they don't. So the whole starting point is one which respects the knowledge and understanding of patients as being there as a potential, and also giving doctors a responsibility to enhance it by any means they can if they're worried about the ability of their patient to understand, or the extent to which they might become upset or distressed by anything they're told. But I think human psychology comes in here as well, and I see time and time again one of the things that medical students become most anxious about in their communication skills training is the session that's often entitled Breaking Bad News. It is a difficult thing to tell people something that you know is the last thing that they wish to hear, or something that they've never even thought might be a possibility, but now presents itself as a devastating impact on their lives. So there's something of a protective element possibly sometimes to think, right, if I can find a good reason not to have to do this, and I'm worried about how good I am at doing this, and I'm worried about my patient, it all comes together to feed into the sort of paternalistic actions we were discussing earlier.
Dr.
Just
Khazaria,
one final comment, if I may. And I've written an article saying that I think the therapeutic exception is worrying and problematic. The GMC, though, has accepted the idea of there being a therapeutic exception in its new guidance. It says sometimes information can be delayed, so long as you make clear to the patient that there's more to discuss, but then goes on to also say that sometimes you can withhold information if it would cause serious harm, and it advises that that's subject to legal advice. But I think it puts doctors and nurses in a very difficult position because it's really unclear what that legal advice might be. I think it's really unclear precisely when this therapeutic exception might apply, and I can't quite see the need for it. It's highly paternalistic in my view, and I think problematic.
Dr. Kazarian, was there anything further you wanted to add on this issue?
I completely agree. I think we need more clarification about what therapeutic exception means and what serious harm means in the circumstances when it comes to patients with capacity. Because if we interpret that broadly, then that can lead to information being withheld from patients. And I think that's why we need to be careful about how we interpret this provision, and I think it should be extremely restricted.
Can I ask you next just a little about the treatment of, treating children in terms of informed consent? The treatment of a child can take place either with the informed consent of a parent or guardian, or with the child's informed consent where the child is GILIC competent. But are there any particular considerations that apply to approaching the question of the giving of information, the obtaining of informed consent in the case of children that are distinct from those applicable to adults?
Yes. So there are some things that children can't consent to. There's been a case recently, case of Bell, where it was held that children in general will be unable to consent to sex hormones and puberty blockers in relation to their gender dysphoria because there's not enough known about the particular treatments or their long-term implications, and those treatments will have an impact for the rest of that person's life. So there is still a degree of paternalism that applies to children, even if the children are said to be competent in order to make that decision. Similarly, there was a case very recently, the case of X, where it was held that even post-Human Rights Act, if children withhold their consent to something that is needed in their best interest, particularly when that's life-sustaining, then their refusal can be overridden in their best interests. So children are treated differently. This is in part due to the UN Convention on the Rights of the Child, which prioritises their best interests. Under the Children Act, it goes even further, and their best interests are the paramount consideration. And this does lead to a greater degree of paternalism, even if it's recognised that that child is competent to make a decision.
If you have an instance in which a parent is being asked to give consent for their child, is there any enhanced obligation on the clinician, given that this is a case of already where, in a sense, respect for autonomy is diminished because the child is not the person, the patient is not the person consenting? Is there an enhanced obligation to ensure that the third party, the parent, particularly understands the full implications and ramifications before they give consent on behalf of another? Or is it the same approach that you would expect if it was the parent's treatment itself an issue?
I think the level of understanding should be the same, but the bar is different. So the court has an obligation to protect the interests of the child. So while we can make decisions for ourselves that involve significant risks and perhaps arguably, adverse risk-benefit ratios, a parent can't make that decision on behalf of a child in the same way as an adult can make it for themselves. And it's the doctor's obligation to decide whether this really is in the interest of the child. So the classic example is adult Jehovah's Witnesses can refuse life-saving blood transfusions. However, adult Jehovah's Witnesses can't refuse a life-saving blood transfusion for their child because that's not in the child's interests. So the bar has to be much clearer when it comes to children about whether this intervention really is in the child's interests or not. But but anyone, whether you're deciding for yourself or your child, needs to understand the relevant information about the options and the risks and benefits.
If you have a case where the child themselves is being asked to consent on the basis of Gillick competence and leaving aside the particular circumstances of cases like the Bell one, is there a particular concern there about coercion and power imbalance that is peculiarly applicable to children, or particularly applicable to children because of they may have fewer life experiences, they may be more deferential, less able to speak up for themselves than an adult?
It used to be that we'd immediately default to describing children as vulnerable, and I think that's come under challenge, particularly where a child of a relatively young age has demonstrated that they have Gillick competence in relation to their own health. And I think research by people like Priscilla Alderson over the years has shown us the extent to which children can genuinely become expert and make good choices. However, their vulnerability might rest in the fact that in a similar way to Emma talking about the gratitude that people felt to the NHS perhaps being a constraining aspect on their behaviour, children are very aware of their parents' feelings, and often if you read accounts of children facing end-of-life scenarios, their primary concern is for their family as opposed to themselves. Now, they're absolutely entitled to make decisions with reference to others, but we would also want to empower a child to ensure that they give due regard to their own best interests. So I think one of the challenges is how best to support a child, even where it would appear that the child and the parent are in accord, to ensure that the child is not shutting down options that would be very good for them for reasons that we don't understand. And that's why I think the GMC and their 0 to 18 guidance is constantly inviting us to bring in all sorts of advice and evidence and views of other parties, not to override that of the child, but to actually, in a sense, validate or verify that we've understood correctly that the child is in a position to make a voluntary decision and is not being either actively coerced or unduly influenced by their concern to do the right thing for their parents or their doctor or anybody else.
I think it's like there are 3 elements to valid consent. It has to be given by a competent person acting freely who understands the nature of the options. Now, each of those 3 elements comes in degrees. There's degrees of competence, there's degrees of coercion, there's degrees of understanding. And the idea of mature minors, children over the age of 16, or Gillick competence was really evolved as we understood that 18 was just an arbitrary line. And so when it comes to children, we have to ask, to what degree are they competent? To what degree are they being coerced? To what degree do they understand? And those questions apply to everyone, but especially to Gillick competent children. And it will vary from situation to situation. And I don't think that, again, it depends on exactly the context. There will be some cases where the child's made a completely free decision, in other cases where they'll be heavily coerced by parents or peers or media influences. So, I think that this idea, of course, the law has to set thresholds, but in reality, there's just a gradation in all of these major concepts. And I think we have to pay more attention to it with the younger somebody becomes. But I don't think that you can give a definitive answer in advance of the context.
We also need to recognise that the bar for competence in relation to children is set at a different level for the bar for capacity that applies to adults. So for adults, there is an assumption that they have capacity to make certain decisions. That's presumed. So you have to rebut that assumption in order to show that they don't have that capacity. but it's the other way around with regards to children. So for a child, you need to be able to show that they have the requisite understanding and maturity to be able to make that particular decision. There is a way, though, in which, given that a parent would be able to consent on their behalf if that child was said to lack competence, it may sometimes be that in practice there's a little less emphasis on checking and making sure they understand something that all are agreed is in their best interests. I think that's the practical reality of it. Because if they weren't to understand it, and if the clinician knows that the patient, the parent also agrees with that going ahead, then there might be a little less emphasis on, do you definitely understand all the aspects of the decision? But having said that, even if the child isn't competent and can't give the authority for a particular treatment, it's still ethically very important to involve them as far as they're able to be involved. So participation is important, even for very young children, to the extent that they're able to understand what's going on.
Professor Fossides, we can't hear you.
That's really helpful, Emma. It puts it so clearly, and it also opens up the possibility of a slightly different form of almost a parental form of the therapeutic privilege, because certainly in work that I've done, one of the issues that arises is a very real concern on the part of parents about the impact of information upon their children, particularly when they've been rushed into treatment after a very difficult diagnosis. And if you think about the context within which you're working, there's a tradition within paediatric medicine of family-centred care. That means that we think of children as embedded within families. We hope those families are supportive and functional and engaged. Sadly, they won't always be. But I think we have increasingly grown up with this idea that there's a form of relational autonomy exercised in that context that is rather different to the adult setting, and allows us to think about a child assenting or being involved in a decision where the parents take the key responsibility for consent.
I wanted to ask you next a little more about the provision of information for the purposes of seeking to obtain informed consent. First of all, if you have a patient who's being seen for the first time for a particular condition or potential need for treatment, is the right starting point for the clinician to assume that the patient is unaware of risks and needs to be informed of the same? In other words, should the clinician be starting from scratch and not making assumptions about what the patient may or may not know?
I think generally that is the right way to go. Because even if they do have some basic understanding, because something's very commonly known, it's still often very useful to have an explanation of it and how it might affect them. And also they might have misunderstandings, and they won't be uncovered and explored unless there's dialogue about those risks.
And if a clinician, is then taking over the care of a patient from another clinician, again, is that clinician entitled to assume that their colleague has provided all necessary information, or is there an obligation to check what has been said to the patient before any treatment continues or resumes?
Well, I think, again, it makes sense to check understanding. And again, from a legal point of view, the liability rests with that individual. So there are legal reasons why they might want to check it, but there are also ethical reasons as well. People can forget things over time. They can form misunderstandings. You don't know for sure that the previous clinician went through all the details. Information might have changed. There might be more information available. So it makes sense to go over things and to make sure the patient has the requisite understanding to make the decision.
I would also say that point extends even to the same clinician. People can forget things over time and gain new information, and I think understanding is an ongoing process. It's not a one-off event. So even with your own patient, I think, I like it when my doctor re-explains things. I have great difficulty retaining everything and keeping my wits about me when I go and see the doctor, and I take notes. But then I often ask questions again to try to understand in an ongoing way.
Professor Phosphides?
Yes, I would agree. I mean, I think a good opening question in any situation where you know that there's important information to be gained is to ask someone what they understand or know of the situation. But there is a balance, I suppose, to be struck, because I think there is a very strong responsibility, following on from what Julian said, on clinicians to be as well informed as they can be before a particular patient or family walk into the room, because there's a cost associated in telling your story again and again, particularly if it's one that includes trauma or distress. And whilst you want the opportunity to tell that story, you don't want to feel that the only way in which a clinician is being brought up to speed again is through your retelling of your story. So if you ask people to provide you with information, I think you also have a responsibility to make good notes about that and to pass them on and make them available to colleagues within who might also benefit within, of course, the appropriate constraints of confidentiality.
And
just to note once more, though, that there are time constraints that clinicians operate under, and sometimes it can be very, very difficult to find the time needed to go into all these issues to the extent that maybe clinicians would want to if they had more time. I'm not saying that that's necessarily an excuse for not going into these things, but I think we do need to recognise that it's widely understood that there are time pressures on clinicians, and that potentially they might have to make decisions about which information they prioritise as a result of that.
Yes, I do hope we have some time to talk about the underfunding of the NHS as a contributor to these ethical issues.
Yeah, because the point may come where your job as a clinician is to challenge the amount of time you're being allowed to speak to your patients for.
But do those observations reinforce, as I think Professor Phosphides has indicated, the importance and value of good record keeping? Because if the records clearly show that the patient has told their story fully and it's recorded, and clearly show an explanation and the prior treating clinician's understanding of the patient's own understanding of the information provided and of the risks, that is at least a starting point, presumably, that might save time and would enable the current treating clinician to deal with essentials.
Yes.
Yeah. Yes, I think it does reinforce that, but it also takes time, doesn't it, to write everything down in the records, and we were just discussing the lack of time. And I suppose the other point, very briefly to make there, is that there was a time when medical records were really just for doctors, for themselves and other doctors, rather than notes for patients to see what's happened, etc., where things might well have been written in a sort of code or in handwriting that was difficult to read, but they could read it themselves. So I think it was 1988, 1990 when patients got the right to be able to access their records. So before then, there might have been a sort of change in relation to the quality of what was, or at least the extent to which things were written down in notes.
And in terms of current gold standard practice, it's sometimes felt more appropriate to write a detailed letter to a patient after a consultation and copy it to the general practitioner, rather than trust that the general practitioner, who, as we know, more than many is under huge constraints of time, will have the opportunity to deal with a letter written in expert language and decode it for the patient. So I think we're moving towards a model that actually requires a very direct form of communication.
Where you have more than one clinician involved in the treatment of a patient, upon whom does the duty to provide sufficient information, in particular about risks, fall? Is it the clinician who might actually be administering the treatment on the day, or is it the clinician who has overall responsibility for the patient's care? Or does it depend?
I would say it depends on who is best placed to enable the patient to understand in the best possible way. Typically, that will be the clinician responsible. But, for example, if a general practitioner refers to a surgeon, the surgeon may be the person best able to explain the surgery. So I think the goal is that the patient understands. So that should be the final outcome, and it will be the clinician who is best placed to enable that to occur.
GMC, sorry.
Or do you disagree, or?
No, I think that sounds absolutely fine. I just wanted to add that the GMC, the 2020 guidance, recognises that parts of the decision-making process can be delegated. But if so, then the treating clinician needs to make sure that it's delegated to somebody that's competent and that has the right knowledge and skill. And that is something that we see in guidance going quite a long way back. So in 1953, the Medical Defence Union document on consent also recognised that delegation is possible, but that the patient must fully understand the purpose of any examination that is made by a doctor to whom that task is delegated, and consents to the results being shared with other healthcare professionals.
Now, in terms of the provision of information about risks of treatment, how should the clinician, in principle, decide what information should be provided to a patient about risks?
Well, in my view, this is fairly straightforward. So I think patients have to be told about common risks, even of minor events, and uncommon risks of major events, and thirdly, of things which would be of particular value to them that don't fall into one of those two categories. So, it's you need to tell people what's important, and that's going to be things that have a major effect on their quality of life or length of life, and also what's relevant to their values insofar as you know them, or you should know them, with some reasonable inquiry.
I think that's absolutely spot on. I think you have a sort of clear set of guidance on the things you need to tell people in particular situations, be that relative to drug risks or procedures, but you then have to finesse that and work with what you know matters to the person themselves, and be particularly sure that you have unearthed the risks that are most relevant to them, because they may not be on either end of that gradient. Might fall somewhere in the middle and not usually be discussed very explicitly. And I think so much of what we've said today has sort of tied up together with this idea that when someone is deciding whether or not to undertake a risk, it is because they think it will bring them something that they value or that they will benefit from. And you need to know how they are characterising benefit to be sure that they have focused in on the most relevant risks, even if they're not the largest risks, but the ones that are most relevant to their situation.
Law on this matter now reflects guidance that has been in place, certainly since 1998, in requiring disclosure of risks and benefits and alternatives that a reasonable patient would want to know, or that actual patient would want to know if they should reasonably be aware of that fact. The GMC has interpreted that in its latest guidance as requiring any risk of serious harm to be disclosed. So that there's a fairly complex debate around what happens when a risk is unknown or can't be readily quantifiable. And previous guidelines have focused perhaps on known risks, but the GMC's iteration certainly incorporates the possibility of unknown risks as well. So it seems then that there's an ethical duty to balance benefits and unknown risks, and to be transparent about these unknown risks in order to allow the patient to make a choice, an autonomous choice.
Dr. Kazarian?
I agree with everything that was said as well. And I think that this links to the earlier point about assumptions made by doctors sometimes. When the doctor, the medical professional, informs the patient of particular risks, they shouldn't make assumptions about what the patient would put significance on, because different patients might find different risks more important to them than others. So that's why, and that's been recognized in the Montgomery decision. What's material is what the patient would attach significance to, but this might depend from patient to patient, and this is where the relationship between doctor and patient is important, and this is where the doctor has to be aware of the particular patient's life and background and position at that particular moment as well.
And presumably a clinician...
Sorry, can I add one thing which I think is relevant to your inquiry, which we haven't discussed it, but Emma sort of briefly brought it up. One thing that is not commonly a feature of disclosure is what is technically called confidence. That is, how confident are you in the figure or the estimate that you give? And that also needs to be, so when she talked about unknown risks, you know, sometimes people will say, oh, there's a 1 in 1,000 chance of this happening. But they're actually, the confidence in that figure is quite low. That's their guess. So it can range all the way from, there is a study of 1 million people that shows the risk is 1 in 1,000 to, well, we think it's 1 in 1,000, just it's kind of low. And I think it's very important to, if people are able to enable people to make decisions, to also convey the confidence that you have, sometimes called the levels of evidence in the information that you're providing, because patients tend to come away thinking that what has been told to them is just a fact. And often it's not a fact, it's an estimate with a level of confidence. And that's something that I think the next generation of medicine will have to accommodate more and more, because things are getting less black and white and more grey. And I think that, and that's also a question of humility on the part of the doctor to say, well, we think this, but we're not absolutely certain. And that I think is important to autonomy, to understand what is certain and what is less certain.
I couldn't agree more, and it's very difficult sometimes to equip people to deal with uncertainty as opposed to certainty, more difficult.
And presumably a clinician should be candid or honest about the limits of their own knowledge and expertise when they're providing information to patients about risks.
Yes, and I think that people are reluctant to say that they're guessing or that they're not 100% certain, because it's seen as a weakness. But it's a reality of life that sometimes there isn't, huge, massive, randomised controlled trials that deliver high levels of confidence. And I think that's a real challenge to medicine to live with uncertainty and to convey that in a meaningful way to patients.
You said in your report it's the responsibility of a clinician to keep abreast of relevant medical developments that are relevant to their areas of practice. Presumably there's also an ongoing responsibility to inform patients if the clinician does obtain more information or more information comes to light. There's maybe a proactive obligation on the clinician to ensure that the patient is given that information, because consent is not a invariably one-off process. It may be a continuing dynamic process.
Yes, I mean, that has relevance in two ways. One is new treatment options or new become available, but even if they don't, if it affects the patient's decisions about their life, their retirement, their marriage, their reproduction, their schooling, their holidays or whatever, it can be important for them to make life decisions that are important to their autonomy and their well-being. But it's not just if this would enable them to access a new treatment. It's, does this provide information that will enable this person to understand their life trajectory and the choices that are open to them?
This may be a standard setting question for Royal Colleges or the GMC rather than an ethical question, but is there some kind of generally accepted minimal expectation in terms of what a clinician will do by way of reading journals or attending conferences and courses or otherwise keeping up to date?
I'm not aware of that being prescribed in that way. And in fact, very recently, I remember reading a sort of reassurance that you can't possibly know everything. But I think what has happened in recent years is that medical professionals have organised themselves in ways that support the sharing of knowledge. If you think of clinical networks that occur around particular diseases, and I think there's a sense in which the GMC certainly says to medical students, your education does not end when you graduate. In fact, that's possibly when it becomes most valuable, because you will combine what you've been taught with a real understanding of what it means to actually do the job. And that's not just experiential learning. There is an expectation to keep up to date in your field, and that's one of the benefits of inviting people to specialise relatively early in their career, because it doesn't shut down all other areas of medicine, but it at least gives them the focus of where they should look for information, and also keep abreast of what's happening when something moves from bench to bedside, when something is introduced. It's no longer part of a clinical trial, but it doesn't mean you shouldn't be minded to be aware of things like adverse events, or look for patterns or trends of things that are being reported in clinics. And we now have the wherewithal to share information so much more easily. I think it's even more beholden upon you to be aware of what's happening in your specialist field.
I think there is, so we really need Ian here, but certainly when I graduated, there was no such requirement to read certain numbers of journals, or it was really based on reputation and status or concern for those things. But in the last 20 years, there has been a program of continuing medical education that doctors have to satisfy to continue to be registered, which will often involve reading some journals and satisfying certain knowledge requirements, or showing that they've continued their education. So I think in the last 20 years, there have become some requirements that have more formalised what should be there anyway.
Just to follow up from Julian's point there, in terms of the GMC, so professional regulation, there was a lot of emphasis until recently on reacting, so responding when something went wrong. And the focus in the last few years has been on something they call revalidation, which is where they require the doctor to show that they've kept up with knowledge and therefore are competent and able to practice. And the GMC in its guidance does require that clinicians keep up to date with knowledge, but also that they act within their competence. So if it's something that they don't know anything about or don't know enough about in order to be able to act in the best interest of the patient, then they shouldn't be doing it. in a way, it's getting easier to keep up with developments insofar as things are digitised now. So it's fairly easy, so long as you can get past the paywall, to search for journal articles on a particular issue. But in a way, it's also getting a little bit more complicated because there are so many journals out there, and it's a little bit more difficult sometimes to work out which are the good ones and which perhaps aren't so reputable.
But I think that skill is now being taught as part of the medical curriculum. And for example, my medical school has developed various apps for medical students to have very quick and ready access to authoritative sources of reference on the ward. The problem is it appears sometimes to patients like they're playing with their mobile phones. So we've got to sort of deal with that side of the problem. But there is a sense, I think, where it is increasingly part of medical education to know that you are not going to always be in a well-informed position. You're not always going to be certain. And one of the skills that you have to develop is how to access quickly and appropriately knowledge and support.
You've said informed consent includes the provision of information about reasonable alternatives to a recommended treatment. Is it also incumbent ethically upon the clinician to spell out that there is always an alternative of no treatment, and to make clear that the patient has the freedom, the autonomy to decline any form of medical intervention?
Yes, I mean, if there's only one treatment option, the patient should have the risks and benefits of the treatment compared to the risks and benefits of doing nothing. Otherwise, they don't have a meaningful choice.
Yeah, I would agree. And it's not always straightforward. I remember some interesting work being done about 10 years ago in terms of reintroducing the notion of conservative management for patients who might benefit from dialysis, particularly older patients, where the day-to-day costs of turning up for dialysis were really burdensome to them. But we had become so convinced of the benefits of a quite invasive but life-changing for many medical intervention, we'd lost sight of that possibility of a more conservative management. And I think in various areas now, it's not just a choice between yes or no. It's, do you want this treatment, or do you want to pull back a little bit on some aspects of it? And for example, in a palliative care setting, we became incredibly excited about the potential around palliative chemotherapy, palliative surgery. And the pendulum is now swinging back a bit to say, actually, the best choice for you might not be to go down a very interventionist path just because that's open to you. But those are very complicated issues to discuss with patients.
Sorry. Excellent points. I just very quickly wanted to add, to follow along from that we need to be really careful when we talk about doing nothing, that it's not seen as a complete withdrawal of care. That actually doing nothing isn't really doing nothing. It's still continuing to care for the patient. So if this is an end-of-life situation, for example, then it might be that the alternative to perhaps aggressive treatment might be a more conservative option, as Bobby was talking about, but that would still involve care. Sorry, Julian.
No, I just wanted to add one thing which is relevant to your question about what is special about children. In general, the issue with children is it's preferable to defer as much as you can, as long as it's not associated with costs, until the child can grow up and decide for themselves. So in all of these cases, there's also another option. There's not only treatment or not treatment, but treatment now, treatment later, versus continuing on conservative management. So there are often, even with one kind of main treatment option, different variants that may be relevant to the patient or may not be. And insofar as the patient may value them or they may have particular benefits to the patient, they should be offered and explained.
One final question from me for today on the question of the provision of information to patients. Is there an ethical obligation on the clinician to inform a patient of the role played by financial considerations in decisions to offer or recommend one treatment over another?
Well, people should disclose any factors that may influence their decision making or may be perceived to be influencing their decision making as well in order to foster trust. And they may be financial or non-financial. It may be that a doctor has a particular religious view that precludes certain options being offered to the patient. And in my view, that can also create a conflict of interest that ought to be declared. But typically a financial or reputational stake, for example, if this is a part of a research project that will offer particular status benefits to the doctor, those kinds of influences ought to be disclosed. So essentially, the doctor ought to declare what factors might potentially influence the way in which they present information or options in order for the patient to be fully able to appraise what's being presented.
One could argue that we should have more open discussions in society as a whole about how funds are allocated to healthcare and then how they are distributed, so that people understand the sorts of financial constraints that may not be necessary. They may be part of, decisions that were made to prioritise A over B or whatever. But I think openness and transparency is incredibly helpful sometimes to turn something that could become an issue, prevent that happening. For example, we might have a good economic argument for moving a patient who has used a branded product of something like an asthma inhaler for the last 10 years. So every time they pick up their prescription, they know what the inhaler will look like. They know the colour, they know the box, they know everything about it. And then suddenly they go and it looks completely different. And it's because it's a generic equivalent and it is being prescribed in large part because it will save resources to be spent on other aspects of healthcare. But we have to appreciate that even that tiny little change could be very destabilising for someone. And if we don't have a discussion more generally about the safety or not of generic drug equivalents, the drive to try and push down the pharmaceutical bills in the healthcare, then a patient's trust will be slightly shaken and the next encounter with the doctor will be diverted into this matter. So I think part of the problem we have sometimes with discussing financial issues is that we don't work hard enough to get everybody to understand exactly how decisions are made and the extent to which individual doctors aren't necessarily the main decision makers at the end of the day about whether you get offered treatment A or not.
Sorry.
No.
One final point in relation to research, which I know we're going to deal with later, but I think in the past where there might have been payments made as part of a research project, there was an emphasis on making that clear to research ethics committees so that the research ethics committee could give its approval fully aware of any financial incentives that might have applied, but that might not necessarily have been passed on to the patient. There's more of a focus now on openness with the patient.
So we'll no doubt pick up some of these issues tomorrow, but in view of the time, I was going to suggest we stop there for today and then continue at 10 in the morning.
Well, let us do that then. So thank you very much for today, which has been most useful. Can we come back tomorrow, please, to start at 10, where we hope that we'll be joined again by Professor Kerridge from Sydney. So thank you very much, and good night. Have a good evening. Stay safe, and good night.
Thank you.
Night to everyone who's watching this from their homes. I'll see you in one sense, but in one sense only, I'm afraid, tomorrow morning.
Thank you. Good evening, everyone.
Thank you.